it is now time for the second panel. I think you guys are going to find this panel very interesting. I had the opportunity to tune in and listen to some of the first panel, and I had an opportunity to listen to the keynote speaker. And I think this panel ties into some of those questions and concerns that you guys were having with the logistics of Zoom and avatars. And so we're going to talk about trial by Zoom, the good, the bad, and the ugly. You're going to get to hear from three wonderful folks today. I'm going to tell you a little bit about them and then introduce their topic and let them talk for about 20 minutes on their topic. So one of the people you're going to hear from today is Professor Nancy S. Marder. She is a professor of law at Chicago-Kent College of Law. She's currently a visiting professor at the University of Toronto Faculty of Law and was a visiting professor of law at Yale Law School last fall. Professor Marder is a professor of law at Chicago-Kent College of Law, where she is also the director of the Justice John Paul Stevens Jury Center. Her research and writing focuses on juries, judges, and courts. She's also written and lectured on every stage of the jury process, from the jury summons to the post-verdict interview with jurors. She also writes about juries and judges in popular culture, the intersection of juries, gender and race, and juries in other countries. She is the author of The Power of the Jury, Transforming Citizens into Jurors, a co-editor of Juries, Lay Judges, and Mixed Courts, A Global Perspective, and she has written numerous law review articles, book chapters, and essays on juries, judges, and courts. Professor Marder graduated from Yale College summa cum laude, received a MPhil from Cambridge, a master's in philosophy from Cambridge University, where she was a Mellon Fellow, and graduated from Yale Law School, where she was an articles editor of the Yale Law Journal. After clerking for Judge Leonard B. Sand in the Southern District of New York and Judge William A. Norris on the Ninth Circuit, she spent 2 years clerking for Justice John Paul Stevens at the U.S. Supreme Court before entering academia. So that's going to be our first speaker. If you want to give a wave, Professor Marder. Am I pronouncing your last name right?
Yes.
Okay.
Perfect.
The next speaker you're going to get to hear from is of counsel, Mr. Charles B. Gibbons from Buchanan, Ingersoll, and Rooney, PC in Pittsburgh, Pennsylvania. He is of counsel at that firm, and he's a graduate of the University of Scranton and Boston College of Law. He is a fellow of the American College of Trial Lawyers and a member of the American Law Institute. During the past 50 years, he has tried dozens of cases in the field as diverse as federal taxation, civil rights, environmental compliance, secondary boycott, defects in design and construction of commercial buildings and sports arenas, torts, and business disputes. In addition to the 7 editions of the federal trial objections, during the past 25 years, he has written a number of other books on evidence and trial practice, including Pennsylvania Rules of Evidence with Trial Objections, the 8th edition, and A Student's Guide to Trial Objections, 6th edition. He also compiled and edited The Art of Cross-Examination, Essays from the Bench and the Bar. Mr. Gibbons has served as chairman of the Pennsylvania Supreme Court Committee on the Rules of Evidence, and was a member of that court's committee, which drafted Pennsylvania's evidence code. He has lectured on evidence at annual conferences of both federal and state trial judges, and has lectured on trial practice throughout Pennsylvania for the Pennsylvania Bar Institute and at the Pacific Judicial Council and Saipan Commonwealth of the North Mariana Islands for the American College of Trial Lawyers. Mr. Gibbons, if you could wave so everyone knows where you are. And last but not least, another presenter we'll have today is Dyane O'Leary. She is she's a professor. Professor O'Leary directs the Legal Innovation and Technology concentration as part of Suffolk Law School's #1 nationally ranked LIT Institute. She is the author of the first student-centered course book on innovation and technology, practical skills for lawyers. Her scholarship focuses on integrating technology competence into the legal practice and broader law school curriculum. She has published and presented and designed courses on topics such as document automation, e-discovery, analytics, cybersecurity, remote lawyering, and law practice management tools. Professor O'Leary will chair the Association of the American Law Schools section on technology, law, and legal education in 2023. She is a Fast Case 50 Award honoree, fellow of the College of Law Practice Management, and was named a Woman of Legal Tech by the American Bar Association's Legal Technology Resource Center in 2022. So if you want to wave Professor O'Leary so they can know where you are on the screen as well. As you can see, it's going to be a real treat today to hear from this wonderful, experienced panel. We're going to start off with Professor Marder. She's going to talk to you, and her topic is Against Zoom and Why Juries Need Courtrooms. So go ahead and get us started.
Great. Thanks very much. And thank you for organizing this symposium, which has been wonderful so far. My central argument today is that although the pandemic led courts to try online or virtual jury trials using new technologies like Zoom, juries need to return to actual courtrooms. Courtrooms are not only places where jury trials have traditionally been held, but also they provide a setting in which ordinary citizens are transformed into responsible jurors. Citizens who might be reluctant to serve enter the courtroom and sense that their task will be out of the ordinary. My broader point, which I make in a recently published book called The Power of the Jury, Transforming Citizens into Jurors, here it is, finally in print, is that jurors are made, not found. In other words, every stage of the jury process, including the summons, voir dire, instructions, and deliberations, helps citizens to assume their role as jurors. They move from individual to group considerations. And the post-verdict interview with the judge helps jurors to resume their lives as private citizens and to serve as emissaries for the jury system. Although every stage of the jury process contributes to this transformation, for today's presentation, I will focus on voir dire and the ways in which the actual courtroom and jurors' physical proximity to each other are integral to this transformation. However, before I get to voir dire, I want to set the stage by describing how jury duty begins with a summons, and the summons can evoke dread. No one is happy to get a jury summons. Even I, who study the jury, am not happy to receive a jury summons in the mail. It interrupts one's daily life, and it never seems to come at a good time. In fact, researchers have found that the number one reason citizens ignore their summons is that they feel they have no control over when they serve. To add insult to injury, when prospective jurors enter the courthouse, their sense of dread is reinforced. They are made to wait in a jury assembly room, and they're given very little information about what will happen next. Some, like me, have never made it beyond the jury assembly room. And if they do make it to a courtroom, they're already thinking about their excuses, why they can't serve. One anthropologist described it as, quote, a culture of excuses, as prospective jurors try to figure out which excuses will work with the judge. But at the same time as citizens feel dread when they receive their summons and when they enter the courthouse, there's another, more positive response that they're likely to feel, and that is that they're being summoned to perform a task that is out of the ordinary. So along with the dread, there's a little bit of awe. It can be the august setting of the courthouse or the symbols of the courtroom, such as the judge in robe, the gavel, the flags, the formal seating arrangement that inspire this awe. And it's against this backdrop, primarily of dread, but a small sense that what is about to take place in this formal building is out of the ordinary, that prospective jurors begin voir dire. The traditional view of voir dire, which is the questioning of prospective jurors either by the judge or the lawyers, or sometimes both, is that prospective jurors' answers will reveal who has biases relevant to the case and cannot serve, and who does not have biases relevant to the case and can serve. Voir dire is traditionally understood as a search for impartial jurors. However, lawyers seek sympathetic jurors, even if they won't always admit it. The judge has to make sure that there's no obvious reason why the prospective juror cannot serve, and has to remove such prospective jurors with a for cause challenge, for which a reason must be given in open court and on the record. There are several impediments to identifying more subtle forms of bias during voir dire, including that prospective jurors give what psychologists call socially desirable answers when asked if they can be impartial, which means they say yes, whether it's so or not. Also, they're asked questions orally, which means they have little time for reflection. And in federal court and in some state courts, the judge, rather than the lawyers, conducts voir dire, and the judge is less familiar with the case. Although there are ways to address these structural problems, such as having a written questionnaire in addition to oral questioning, or having the lawyer, under the supervision of the judge, conduct voir dire, even with these changes, the traditional view is that lawyers and judges can uncover biases, including subtle or implicit biases, even though psychologist studies suggest that they cannot. Such studies show that it's hard for people to identify their own biases, and it's even harder for someone else, such as the lawyers, to discover another person's biases. If lawyers and judges cannot discern subtle biases, should we abandon voir dire, as some countries have? No. Voir dire needs to be recognized as serving a different purpose, which is helping citizens to assume their role as impartial jurors. So how does voir dire do this? According to my transformation view of voir dire, what's important is beginning the process of transforming citizens who are busy thinking about their excuses and why they can't serve into jurors who want to serve. From this perspective, what's important about voir dire are several features, all of which require a courtroom. One important feature is that prospective jurors are seated together in the jury box. They sit together with each other during voir dire in a jury box that is separated from everyone else in the courtroom. Being together with each other and apart from everyone else will be a defining feature of their role as jurors, a physical manifestation of their role. They can also observe everything going on in the courtroom, but they quickly realize that they are being carefully watched by everyone else in the courtroom. They understand that they have to try hard, like the judge, not to show agreement or disagreement with anything that is said in the courtroom. They need to appear impassive so that they show that they are open-minded and impartial. Second, prospective jurors during voir dire are questioned orally as a group. Although this might not be the best way to elicit information from them, the group questioning is very important. Group voir dire gives the jurors a shared group experience. It allows them to learn about their fellow prospective jurors, even if it's just basic background information, like one would learn about a person at a cocktail party. It allows them to start to feel comfortable with each other. Group questioning also allows the prospective jurors to hear each other say that they can be impartial. So as they hear others say that they can be impartial, they start to think that they too can be impartial. Group questioning also means that all the prospective jurors have the same information about each other, such as that they've all said that they can be impartial, and that they have the same information from the judge. They are being treated as equals, which is how they will learn to treat each other. It's also important that the judge is doing the questioning, even though the lawyer might know more about the case, because it marks the start of the judge-jury relationship. The back and forth between judge and jury begins during voir dire, continues throughout the trial, and ends when the jury is dismissed, or in some courtrooms after the judge and jury meet for a post-verdict interview. During voir dire, the judge can help jurors understand their role. One of the questions the judge always asks is whether the prospective juror can be impartial. This question pushes prospective jurors to think beyond their personal concerns and to ask themselves whether they can serve. At some point during voir dire, prospective jurors begin to hope that they will be selected. Psychologists note that people have a tendency to maintain that they were present at a significant historical event, even when they were not, because they want to be part of history. The opportunity to be on a jury may work in a similar way. Those who are present in the courtroom during voir dire can almost feel the change when prospective jurors shift from wanting to be excused to wanting to serve. It's almost a palpable moment in the courtroom. Juror accounts of their jury service support this shift. Those who are not selected feel disappointed, even if they didn't want to serve initially. The prospective jurors who have been selected to serve on the pedijury stand and take an oath together. They say the oath before everyone in the courtroom. As one former juror noted, quote, "The only other occasions on which such solemn undertakings as an oath are pronounced in public are weddings and christenings," end quote. My argument is that voir dire is important, not for the reason the traditional view suggests, which is to weed out biased jurors, but because it helps citizens to be transformed into responsible jurors. Voir dire facilitates this transformation so that citizens who wanted to be excused when they first entered the courtroom now want to serve. Or as one juror said, quote, "I was suddenly rather keen to be on the jury." He was a British juror, end quote. There are steps that judges can take to aid citizens in their transformation into jurors. One step is asking different questions. Judges should still ask prospective jurors questions about their background, but they should not attempt to uncover subtle biases. They should also provide more information about the roles of judge and jury and the challenge of judging. In addition, they should identify useful behaviors for jurors to engage in, such as listening carefully, thinking critically, maintaining an impassive expression in the courtroom, and treating fellow jurors with respect. They should describe differences between the judge's role and the jury's role, as well as what the two roles have in common. A second step is judicial training. Judicial training programs for new judges should add a section on fostering the judge-jury relationship. Many programs teach substantive areas of the law or case management and settlement techniques, but they need to teach judges to ask, if I were a juror, what would I want to know at this stage? In other words, judges need to take what I call a jury-centric approach. They need to put themselves in the shoes of a juror and ask what the juror would need to know. A third, more controversial step would be to have jurors wear robes or badges. One way courts can help citizens to assume their role as jurors is to have them literally slip into that role by putting on a plain black robe like the one that the judge wears. They could put on a robe just as judges do, or as judges, barristers, and clerks do in England and Wales. They could skip the wig, or as judges, lawyers, and registrars who are like bailiffs do in Canada. It could be tried as a pilot program, like so many other new trial practices have begun, such as having jurors submit written questions to witnesses by way of the judge. Robes for jurors would be a tangible reminder of their role and would signal their role to others in the courtroom as well. Alternatively, jurors could wear a badge with the word juror on it and a court insignia, like conference attendees often wear, as a way of fostering a sense of belonging to the group. So how would judges and courts help foster this transformation of citizens into jurors that I've just described if jury trials were held online using Zoom or some other technology? It would mean that prospective jurors are not physically together to begin the process of becoming a group. Without a courthouse and a courtroom, prospective jurors would lack the setting that would convey that they are about to embark on an out-of-the-ordinary experience. For example, with Zoom, in which everyone appears in their home or office, as we are all now doing, there is nothing to indicate that the work that is about to commence in the courtroom is of unusual significance. With Zoom, prospective jurors would not feel that they're connected to each other. Instead, they would be separated in their individual Zoom boxes. Moreover, only their faces would appear. Typically, we get to know each other by recognizing the whole person, not just a disembodied head. With Zoom, jurors would only have a limited view of the courtroom, depending on where cameras are placed. Presumably, they would see the judge, a testifying witness, and the lawyers, but there are other trial participants that they might not see, such as the parties, particularly a criminal defendant who typically does not take the stand. One article has described these observations that jurors make as, quote, off-stage observations, end quote, and has described the courtroom as a theater in the round. This view of the courtroom and the trial participants would not be available to jurors on Zoom. In addition, jurors would not be able to take their oath together. They can't all speak at the same time on Zoom. They would have to speak individually and by themselves, so the oath would not be a group experience signifying shared responsibility in the way that it currently does in the courtroom. Judges and courts need to think carefully about the effects that these online changes will have on how citizens become jurors. The transformation view directs our attention to the critical but unacknowledged ways in which voir dire helps to transform citizens into jurors. Rather than focusing on the traditional view's emphasis on voir dire as enabling judges and lawyers to discern subtle biases, we need to ask how Zoom voir dire would recreate the jury box experience, the group questioning, the judge's questioning of the jurors, which begins the judge-jury relationship, and the jurors' oath-taking as a group, so that voir dire continues to help citizens who initially think about jury service from their own convenience to become jurors who think about the group effort. This transformation is what enables prospective jurors who don't want to serve initially to become jurors who ultimately take their responsibility seriously, believe that they've done a good job, remember their jury service as a positive one, and think more highly of the judiciary after they have served, according to surveys of jurors. Although I have focused on the importance of voir dire in transforming citizens into jurors, this effort is not limited to voir dire. Indeed, every stage of the jury process that follows voir dire, including the instructions and deliberations, continues to develop this group sense among the jurors. A Zoom jury trial would undermine this group sense, similar to the way that a Zoom classroom or a Zoom conference falls short of creating the interactions that foster a group experience. Although this is a loss for students in the classroom and for academics at a conference, it's an even greater loss for juries because they have to make a group decision that has consequences, sometimes life or death consequences for the parties who appear before them and whose lives can be profoundly affected by a jury verdict. Thank you.
Thank you so much, Professor Marder. I don't know how many of you are on this presentation that have had the opportunity to get to do a jury trial, and listening to Professor Marder talk, it just reminds me of the magic of getting to step into a courtroom and getting to see all of that come together from voir dire to closing, whether it's your first time and it's scary as heck and you just make it to the end. It really is an experience to get to go into the courtroom and do a trial. And I think our next speaker is going to tell you about some of that magic in his presentation. He's tried cases in various state and federal courts for the past 50 years, and he's going to respectfully submit to you that there is no substitute for conducting depositions and all jury and bench trials in person. He's going to talk to you about how the necessary dynamics among and between the witnesses, jury, judge, and trial lawyer are utterly lost and fatally compromised by the use of Zoom and other remote technologies. So continue and share the magic, Mr. Gibbons.
LeTiffany, would it play havoc with your time if I said I listened very carefully to everything Professor Marder said? I adopt her views and I have nothing more to add.
Maybe tell a little bit more about the in-person experience of trial.
I'm only kidding.
Oh, okay. I was like, I just talked you up. I tell them about the magic, and then you say ditto. You're good. You're good.
I give you credit for making LT speechless. I have not seen her speechless in quite a while.
I am rarely speechless. That is true. You can carry on, Mr. Gibbons.
First of all, I want to thank you and the law school for the invitation to appear today. When I talked to the law school last year by Zoom, I told them that I very much wanted to come to Topeka and spend time in the Ichabod Nation and get to know that part of the world and the students in particular. And unfortunately, I was not able to fulfill that promise this year, but if the invitations keep coming, I promise that I will find a way to get to Topeka and spend time at the law school. Not to put too fine a point on it, I think a virtual courtroom from my own 50-year experience is absolute rubbish. I know there's that line from Shakespeare that men abed this day will curse themselves that they were not with Harry on Crispin's day. 50 years on, I have been with Harry on Crispin's day, and I would like to talk to you a little bit about what those experiences have been like. 50 years obviously gives you a lot of scar tissue, and I want to share some of that scar tissue with today's group in order to buttress my belief that Zoom is not and never will be a substitute for in-person depositions and trials, and that is whether those trials are bench trials by the judge or jury trials. Let me start with depositions. And I have to give a little background here. I tried a case years ago that involved the Taft-Hartley Act secondary boycott. It was a union violence case where I was representing a very, very large non-union operation here in Western Pennsylvania. Now, the tactics of the United Mine Workers were that if they could shut down non-union coal, then the plants in Detroit and Chicago and Baltimore, Kansas City, that used coal to generate electricity, if you could starve them of not only union coal, but non-union coal, then the politicians in those states would put all kinds of pressure on the owner groups to come to terms with the union. And so in the case I had, our operation, which was spread out over hundreds and hundreds of miles of square miles of territory here in Pennsylvania, came under constant attack for the 3 months of the strike, sometimes involving gunfire, sometimes involving trying to set our facilities on fire, sometimes with mass picketing. So we filed suit in federal court under Taft-Hartley. And I began to take the depositions of the various folks who had been arrested during the course of this mass picketing. Now, I have to tell you that I am extremely nearsighted. And when I take off my glasses, the world becomes an impressionist painting. It's colors, they blend together. I can't stare you down because I can't see your eyes. All I can do is see the colors all blending together. And I was taking the deposition of a chap who was arrested at one of our facilities for trying to light it on fire with several hundred of his fellow strikers. And the technique the witnesses were using was duck and cover. And it went like this. Your name is John Smith, is that correct? Yeah, it is. And do you live at such and such Stone Ridge Drive? I'm not sure. Are you a member of the United Mine Workers? My memory is really lousy. Were you arrested at the C&K Piney Tipple? I don't specifically recall that either. I'm trying hard, but I just don't recall. And at one point, very early in the deposition, I took my glasses off just to try and figure out how to get past the duck and cover. And as I was thinking across a minute or perhaps two, the witness suddenly blurts out, wait a minute, you know everything about me. I lost my wallet at the Tipple that night. You guys found it, and now you know everything about me, so I may as well tell the truth. And he proceeded over the next hour to lay out how miners, striking miners from Pennsylvania, West Virginia, Ohio, and Maryland would come together at various rallying points and create a caravan of vehicles running to several hundred vehicles to descend on our operations. We never found the guy's wallet. I didn't know a damn thing about him. I was just trying to figure out how to get past the, I don't recall, I can't remember. I would submit respectfully, that kind of a dynamic between the interrogating lawyer in a deposition and a witness is simply impossible if you were trying to do it by Zoom or some other automatic technology. I just don't believe it could happen. And I'll get to later a Zoom trial that I had that paled in comparison to anything I had ever done in a state or federal courtroom. I would make one exception, and this is nothing new in the trial courts as I have experienced them over the years. I would make an exception for a deposition of a witness where you need to establish a fact for the record. The other side will not stipulate to it, but nonetheless, it is not controversial. I have had federal judges in cases where they understood a witness had a small but necessary fact to supply. Tell both counsel, we are not going to bring that fellow in from Vancouver, Washington. You're going to call him on the telephone and we will hear his testimony in the courtroom by telephone. Now, I think the same thing can be done on occasion with witnesses where there really is no contention, but you have a record to make. But in the ordinary course of deposition examination, I really do submit that it just cannot be done with me sitting in my law office and a witness sitting in the office of the defense counsel and trying to do this by Zoom camera. In that regard, I would recommend to those who care to read it, a case called Barksdale School Portraits versus Williams. And that appears in 339 FRD at page 341. It's from the District of Massachusetts, and it's a 2021 case. I would be even willing to bet that Professor O'Leary is already familiar with the case, and if she isn't, she will be 5 minutes after we finish this. The defendant in that case was represented by one Jeffrey Rosen. I don't know who he is, and it really doesn't matter, but his name is important because the Barksdale case came before the federal district court in Boston on a motion for sanctions. And the motion was directed at Attorney Rosen. And importantly, the court recites in the front part of the case, Mr. Rosen took advantage of the remote nature of the deposition proceedings to surreptitiously provide Ms. Williams with the answers to dozens of questions asked of her during the deposition. Now, am I so cynical as to believe there are a lot of Jeffrey Rosens out there in the various bar associations? I don't want to answer that question. I am not going to answer that question. I am simply going to leave it at my belief that Zoom depositions create possibilities for mischief. Let's move on to my trial experience. Some years ago, there was a skyscraper here in Pittsburgh where the outer skin of the building, which was granite slabs of several thousand pounds weight, began what they called in the construction parlance walking. What that meant was they were moving back and forth against each other towards the day when they would fall off the building. And the bank was the plaintiff in this federal case. There were 9 defendants. My client happened to be one of them. It was a 10-week trial, and I got dismissed with prejudice after week 8, since there was no evidence my client's steel angles, which held the granite slabs, had any involvement in the failure of the slabs. And I remember early in the trial, and this shows you how long ago it was, probably 30 years, the lawyers, the 9 defense lawyers, the plaintiff's lawyers, were in the front of the courtroom door having our last cigarette before the trial started. And a juror came in carrying a plastic bag. And somebody asked the jury, what's in the plastic bag? And I have to stop here for a moment to tell you that one of the defendants was a national or international construction company. They had been the construction managers for the building. The case was brought 5 or 6 years after the construction was finished, and all of their people were in the Middle East. Most of them were in Saudi Arabia. And the depositions were taken by videotape, and the defense counsel told the jury the day before that his people would be appearing by videotape. And they started in the middle of the afternoon. The first 2 witnesses come on videotape. And the incident I'm talking about is the very next morning. The juror has the bag. He was asked what was in it, and he said popcorn. And somebody said, well, why popcorn? He said, well, if it's going to be day at the movies for the next 2 days, I think we ought to at least be able to sit and watch the movies and have popcorn at the same time. Now, I have to tell you, it wasn't a jury full of wise guys. This trial went for 10 weeks, and these people agreed to sit as jurors for 10 weeks. And that shows the kind of seriousness that Professor Marder talked about that comes about once a jury is impaneled. But that was his view of things. If it's day at the movies for the next few days, let's have popcorn. Now, I have tried in the course of my 50 years, 4 cases that went 2 months or longer. And I respectfully submit there is no way in hell you can have a case for 2 or 3 months and do it by Zoom. I just think it's absolutely impossible to maintain the continuity and the atmosphere that a courtroom provides doing that on a television screen. When I say cases that went 2 months or more, I'm not talking about trying a case a day here and a day there, as sometimes happens. These were cases that were tried day after day for, in 2 cases, 2 months, and in 2 cases, they went 3 months. I just can't believe that can be done by Zoom. One of the things, and it touches on what Professor Marder was talking about, was I had a case some years ago where it started on the 16th of November, finished on the 10th of January. And I was the plaintiff for the University of Pittsburgh, and there were a whole bunch of defendants, and it concerned the construction of their sports arena. And as luck would have it, or unluck would have it, I had 3 witnesses from Kansas City who I wanted very badly to be able to come and testify. It was critical evidence. And God bless them. They agreed to come where they fell in my schedule of witnesses, Thanksgiving week. And they flew to Pittsburgh on the Sunday before Thanksgiving. They testified Monday, Tuesday, Wednesday, and they flew out, thank God, because we couldn't even guarantee there would be a plane ride back to Kansas City on Wednesday night before Thanksgiving Day. And you can believe that I wanted the jury to understand the sacrifice that these 3 men made by coming to Pittsburgh, Pennsylvania, Thanksgiving week, to testify that the case was important enough to them that they would do that. And they were not the plaintiffs, and they weren't on the plaintiff's side necessarily. They were neutral witnesses for steel that had been made out in Kansas City. And I think the jury witnessing the devotion of those 3 individuals was a very, very important part of my case. I also had a case later on that involved the drying of sewage sludge. I often wondered why I had, I think it was 14 years of Jesuit education to wind up talking about sewage sludge. But there I was. And the notion was that the sludge coming in from the city of Harrisburg would go through a chemical process, which was really not important for the jury to understand, but then go to a drying building, conveyed to a drying building on a conveyor, this wet sludge, dried out on these huge drying drums, conveyed down to sludge dryers, dried to the consistency of dog food, and then blown into the city incinerator where it would be destroyed. And so you would skip the whole landfill process, which was becoming pretty dire here in the East, to find facilities that could continue to accept sewage sludge. System didn't work for any more than about a minute and a half. And the important thing was for the jury to understand what that drying process was all about. Now, I have to tell you that the 9 defendants consisted of a lot of engineers who, in my judgment, wore $1,000 suits and couldn't talk to people who wore blue jeans and t-shirts. And so what they did was, the defense strategy was to say our people weren't smart enough to run the equipment. And it wasn't the fault of the design engineers. It was the fault of our workers. Now, a bunch of our workers, in fact, had college degrees. One guy had 3 years at the Naval Academy before he decided that he didn't want to be a naval engineer. And they were very much smart enough to run this equipment if the damn stuff worked, but it did not. And so the waste of Federal Clean Streams Act ran to the millions of dollars. I wanted the jury to see that drying building and the process, even though the thing hadn't been run for years. I wanted to have them see that process and then measure that by these guys were too stupid to run the equipment. How do you do that on Zoom? Well, of course, you could photograph the building and you could have somebody with a camera walking through and all of that stuff. Is that really a substitute for taking the jury? We had buses waiting for them outside the courthouse. We took them the 3 miles up to the plant and we walked them through and we explained every step of the way what was going on. Now, again, I would concede it can be done on television and with drawings and maps and all the rest of that. Hoorah. Does it have the same impact as those people walking through the plant and figuring out for themselves why somebody 3 years at the Naval Academy could or could not run that equipment? And I think that would be lost, frankly, in a Zoom trial. Thank God here in Pennsylvania, when COVID hit, our trial court shut down. They didn't try and play games of trying to figure out how to run a Zoom trial. And so we went from approximately March 2020 until I think well into the late spring, summer of 2021 before we resumed jury trials. Once the COVID levels had reached a point where it could be truly said they were under control, that's when we resumed jury trials in person. They started out in our convention center, which of course is a huge facility. They only tried to run 3 trials at a time. They had everybody spread out so far that in a way you had to yell to convey your questions and so forth. But that's where they started out until they gradually worked back to the courthouse itself. My own Zoom trial was a American Arbitration Association trial where the arbitrator decided that given some issues in his office staff and their concern about COVID, that he would run the trial with him in his law office, plaintiff, who was my client, in our law office, and the defense in their office. And I should tell you in advance that our firm, a year or so before, had moved into a refurbished classic building here in Pittsburgh, where the developer poured in about $300 million to bring the thing up to state of the art. So there was no question that our equipment, the equipment of the court reporter, the equipment of the other parties in the case, was absolutely spot on. It was the latest stuff that was available. Nonetheless, the arbitrator said from time to time that the parties and the witnesses looked as if they were in federal witness protection, because they really couldn't make out our cases or our faces very well. And I have to tell you that in the questioning, direct examination, cross-examination, it was absolutely perfunctory. It bore no relationship to anything I had done or my opposing counsel, who was also a very, very experienced trial lawyer here in Pittsburgh. No relation to anything we had done in the decades earlier before this Zoom trial. Now, I have to say, it's not sour grapes on my part, because I went into the case thinking that it was worth probably about $750,000 to my client. In the process of writing the post-hearing briefs, we got an offer and settled the case for $4.5 million. So it's not as if I was disappointed by the process. My client was doing handstands, but the process itself was a pale resemblance of anything approaching a jury trial or a bench trial, for that matter. All right, where is Zoom here to stay, at least in my experience? Well, I have to tell you that in the state court and for decades, we had something called the Discovery Court Friday afternoon. It was called Happy Hour. And any contested or even uncontested motions dealing with discovery could be brought to Happy Hour. If they were contested and in a complex civil case, which mine usually were, I showed up at 1 o'clock with everybody else, and I sat around till 4:15 till the judge got to the contested complex case motions. That, of course, raises the ethical question. I had sat there for 3 to 4 hours and yet appeared in front of the judge with the argument for maybe 25 minutes. What do I bill the client? Do I bill the client the 5 hours or do I bill them the half hour that it actually took me? But that's the way we proceeded here in the federal court until COVID, and that judge retired and the new judge came on who announced earlier in the springtime that happy hour was ended. There would be no more happy hours. That he had run for judge here in Pennsylvania. He was a very active trial lawyer in order to be in the courtroom, not sitting around, screwing around with discovery motions. And he was going to take them on the paper. And in rare cases, he might take them by telephone. And in even more rarer cases, he'd take them on the Zoom, but he was not going to take them in the Friday afternoon happy hour. That's not going to change. That process of dealing with motions, either by Zoom or telephone, I anticipate is here going forward. I talked to a federal judge the other day, and she told me she will not go back to motions being presented in her case in person. And again, she didn't give the same reason as Judge Nelson. What Judge Kelly said was she got so much more done in a given day by having motions by Zoom or by the telephone, as opposed to having people coming in and out of her court. She said it will be the very, very rare occasion that she'll have lawyers in her court on a motions practice. Now, I would contrast what I anticipate is going to be the rule here in Pittsburgh and here in Philadelphia with what goes on in the more rural areas. And I have to perhaps explain to some in the audience. In the great Commonwealth of Pennsylvania, you have Philadelphia on the east, you have Pittsburgh in the west, and as Richie Allen, the Phillies ball player, said years ago, and Alabama in between. But that's really not fair. What's in between are a bunch of rural counties or counties in which the population is very, very small. Do I anticipate they're going to use Zoom for motions? Absolutely not. In those places, I anticipate, and I love practicing there. I would rather try cases out there, frankly, than try them in the state court here in Pittsburgh, not federal court. I love being in federal court, but I would rather be in the smaller counties in the state court than here in Pittsburgh, because everybody knows everybody else and everybody knows the judge. And it's a very collegial atmosphere that's absolutely missing, especially in Philadelphia. In Philadelphia, when I was trying cases down there, I could not believe how the counsel treated each other. And I always thought it was because they believed they'd never see their opponent again. The bar was so big, chances of running into that lawyer again were minimal, and therefore you could treat them like crap. That's not true here in Pittsburgh. It's a smaller bar, but it certainly is not true in the smaller counties where collegiality carries the day. And I would simply end by saying, and I hope that doesn't change, I had a case down in Rockingham County, Virginia, some years ago in the federal court that is right next door to Charlottesville, where the University of Virginia is located. And as we came into the courtroom, the clerk came out and she said, now, when you finish the argument, counsel, I want you to stay here because Judge Michael likes to talk to everyone who comes into his court. So we made this vigorous and contentious argument in front of Judge Robert Michael. And when we ended, Judge Michael left the bench, went back in chambers for a minute, and then came back out and spent at least 10 minutes talking to counsel. Is it your first time in Rockingham County? Well, maybe if you don't have to rush back to Pittsburgh, these are some things you might go and see. And this is a restaurant that you might want to use. And if you want to duck next door to Charlottesville, these are some things you might want to do over there. And really, as a 35-year-old attorney, did I feel really important and part of the process? Because Judge Bob Michael took the time to talk to us. Human being to human being, lawyer to lawyer, judge to lawyer, however you want to categorize it. Absolutely. That was a wonderful day in the United States District Court for the Western District of Virginia, sitting in Rockingham County. And I haven't forgotten it to this point in time. That can't be done by Zoom. Thank you.
Unmute myself. That's unique to Zoom. You forget to unmute yourself. I hope that you guys have gotten the feeling that there are just some things that Zoom can't do, and that courtrooms and in-person places for depositions and trial really create unique experience and opportunities for you. Mr. Gibbons talked about there is a place for Zoom and litigation for those motions. I've also seen them for status hearings and other dockets where they used to have people come in that have made it more available to defendants. So there's some places where I think Zoom's here to stay in litigation, but for those trials and bench trials, maybe not so much. And Professor Marder, I saw you had your hand up. No? Okay. Okay, so we're going to turn the tide a little bit, and we're going to have Professor O'Leary talk to us about the growing digital divide, security, confidentiality, and privacy in an emerging virtual court process. She's going to talk to you about security, confidentiality, and privacy, how they've always been concerns in physical courtrooms, not only for trials, but at every stage of court involvement. However, the pandemic prompted an explosion of Zoom proceedings, brought about the next wave of hurdles and security best practices, from meeting controls aimed at preventing Zoom bombing to embarrassing screen sharing mishaps. Now the future post-pandemic wave of online court processes threatens to create an even greater digital divide between those savvy enough to access justice remotely and those not. And with that, I turn it over to you, Professor O'Leary.
All righty, good afternoon. Thank you very much. Can everyone hear me okay? Thumbs up. Okay, it's great to be here. I am in lovely Boston, but I wish I was further west in lovely Kansas. I was looking forward to that, but thanks so much for having me. I wrote down on a little index card 2 things that I want everyone to think about, and I realize I might be the last participant in the entire symposium. Is that true, Marisa and Elisabeth? So I am very aware I am that which stands between all of you and the rest of your day, and we'll try to be brief, and especially so we can have some Q&A and discussion. But I wrote down something I heard from Professor Marder and Mr. Gibbons that I encourage you to think about during my remarks as well. One was, do we have the quote possibility of more mischief? So that was a phrase that struck me. And the other one was, do people let their guards down without the magic of the courtroom? So those are 2 things that I've heard that I do think connect to my remarks. Security, confidentiality, privacy, virtual court processes, those are huge topics. The goal of my remarks is not to give a narrow thesis or perhaps an argument, if you will. I've done plenty of presentations where that is the goal. This is not one of them. My goal for this is frankly to stir up a lot of food for thought and really try to stretch our imagination and get forward thinking. I don't have answers. I might pose more questions and concerns and perhaps leave it a little open-ended, but I'll own that at the outset that that is the goal of my remarks. I also appreciate my lack of experience when it comes to juries and courtrooms. I was a former litigator, but I haven't been in a courtroom representing someone in a decade. And that's why I love symposia like this, because it's a great opportunity to combine those practical perspectives with those of us that aren't in the courtroom, but just doing a lot of research and thinking about what lawyers need. If it's okay with the coordinators, I'm going to go ahead and share my screen for a few slides. So hopefully you can see that, and I encourage you to adjust your Zoom settings so you can still see me more than my slides. So big picture, we're going to start with a little bit of a story. We're going to go further out west than Kansas, right? So put on your travel gear, and I'm going to introduce you to Mr. Suffolk and Mrs. Suffolk, who are getting a divorce. So we're going to warm up by thinking about these ideas with a little story. So Mr. Suffolk and Mrs. Suffolk were married about 10 years ago, but in 2022 need to start divorce proceedings. They live in Clark County, Nevada, which is near Vegas, the largest county in Nevada. They proceeded amicably at first, and were intrigued at the court's website that had the Clark County Family Mediation Center using online dispute resolution. And it, quote, promised them fingertip access to custody dispute resolution from any device at any time with powerful workflows and sophisticated technology. So they said, that sounds great. We're going to get our divorce that way. We're going to avoid, 2.5 years of awkwardly running into each other in a courtroom and a lot of money. So all went well. They uploaded certain documents. They disclosed certain finances. They shared intimate details about their schedule with respect to their children. Things went bad, as they often do in family law settings. And Mrs. Suffolk decided to upload an audio recording of Mr. Suffolk's threats against her. And also a text chain that purportedly showed Mr. Suffolk admitting to drug use in front of his children. Months later, when they eventually did have to go to court, Mr. Suffolk, finally with a lawyer, was able to prove those were actually fake, that the audio was a deep fake recording, and the text chain was altered with a new contact that pretended to be Mr. Suffolk, but in fact was not. During a Zoom proceeding finalizing the divorce, when Mrs. Suffolk breaks down crying and discloses all sorts of personal medical information, Mr. Suffolk is so scorned, he posts that audio, which he had been recording on his cell phone next to his laptop, on a YouTube channel, and he also shares it with his 24,000 Twitter followers. So that is the experience in virtual court of Mr. Suffolk and Mrs. Suffolk. Alrighty, one more warm up. So the teacher in me, I see Dean Grant on the Zoom, who I know well, and anyone who teaches in law school knows we can't do anything without involving our audience. Take 20 seconds, take a look at my checklist. So security, I said, was a big word. Glance through this and ask yourself, what have you done today? Have you, in the context of uploading a document, joining this Zoom, emailing anyone, communicating with anyone electronically, which of these have you done? And you are all saved from real participation because I don't think the chat is enabled for all of us to share our scores, but I will disclose I did not score a 10. I have not done all of these things today. But in terms of those big ideas about security and cybersecurity in the virtual age, I thought it was helpful to kind of put it in a more tangible format of what that actually means from a user point of view sometimes. Alrighty, what does all of deep fakes and Nevada and divorces and whether I turn off my Alexa in the morning, what does that have to do with anything? So the premise of my remarks, I think, is pretty simple. It's that two things are on the rise. One is the beyond Zoom. So when I saw the title of this symposium, I took that literally, beyond Zoom, like what else is going on beyond Zoom? So that's one premise, a lot. Right? Courts have more doors open online, and it's not just video conferencing anymore. So that's kind of the one piece that I'll start with. The second piece is what else is on the rise? A whole lot of mischief, to use Charlie's term, with respect to cybersecurity. Laws about what we can and can't do with electronic information, why people want it, why it's valuable, how it can be manipulated, how we're accessing it through mobile devices and working remotely. So that's the basic premise, that as courts are essentially opening more online doors, besides just video conferencing, and all of these security threats and interest in all of this ripe, sensitive data, dates of birth, privacy information, children's name, financial accounts, right? We all know that court cases can often kind of be a treasure trove for juicy information. Both of those things are kind of going into the beyond and on the rise. What that means, that's where I'll leave you hanging. I don't know. The point of my remarks is that it's worth careful thought. It's troublesome, it's worth paying attention to, and there's a lot going on. So that's kind of the big picture. I am certainly not adopting, as much as perhaps we've heard throughout the day, a yes or no. I'll end in the middle. I think that a lot of this is moving in a forward direction. But it's not so much as to kind of be leaping decades from now. So big picture, we heard a little bit about this. I caught the end of the last panel, but that first premise, what are courts doing now besides video conferencing? Let's just think big picture. So decades ago, courts started to experiment with e-filing and remote case management, right? And that was kind of the one door that was propped open so slightly. Decades went on and courts have opened that door a little more. Can you pay through a credit card? Asynchronous ODR, which I'll move to next. How are you accessing and interacting with the courts? Transcription services, video conferencing, audio conferencing. I caught the end of the last panel in terms of where are we going more besides these type of supportive technologies and kind of that post-pandemic wave that I appreciate this symposium giving us the opportunity to think about. And that's kind of the idea of the metaverse, right? And virtual proceedings in that sense. Actually, yesterday I heard something, instead of Internet of Things, I heard this referred to as the Internet of Disputes, IOD instead of IoT. And I thought, wow, that's crazy, but wow. And so that is kind of, I think that's helpful to say that it's beyond Zoom, right? Video conferencing might be a piece along this path, but it's certainly not the only entrance into courthouses anymore. And that's my little, that's about where I think we are in 2022, right? We're inching there. We're not quite there yet, but that's, if I had to place 2022, I'd place us right about there. So big picture beyond Zoom, I'd like to focus on ODR, and some of the students I assume on this meeting might think of ODR in the private sense, right? ADR online, negotiation, arbitration, kind of a non-court involved way to resolve a dispute with technology. And this of course started with companies like eBay, now PayPal, Etsy, doing this type of resolution outside of the courtroom, kind of that business to consumer model. So that's still happening, but more and more, kind of the next wave of virtual doors being open, if you will, is ODR. And so this graph from the ABA in 2020 talks about kind of what other doors are opening, right? Document management, parties uploading documents, interfacing with the court's case management, scheduling, paying things, kind of going back and forth, chat mechanisms, and video conferencing. And so there are plenty of statistics about the growing nature of ODR in the United States. I could spend an hour talking about them and listing the states that are doing it, and thinking about kind of how parties in areas like family law and housing and small claims and traffic is a huge one. How is the court, frankly, not just a physical place when we think of the word courthouse and courtroom? I encourage us to start thinking about it broadly of court system and court processes, and not necessarily a physical place anymore, but a wider, virtual location through which people are going to interact in a lot of different ways. Who is doing this? So those are a lot of pictures, a lot of companies, and my bottom line here is a lot of people are doing it, and this brings a lot of risk. I wanted to spend a time thinking about this. 30 years ago, when you bought a TV, 40 years ago, you probably had, I don't know, 2 or 3 choices, maybe. You go to buy a television now for your living room, you have 80 different choices, right? With every bell and whistle and vendor and type and brand. Right now, we're kind of in that pandemic exploded Zoom scene, if you will, where Zoom feels like the only player in town, or perhaps, Cisco or some of the other larger video conferencing. But again, this is kind of trying to be forward thinking for those students out there. There's more people knocking at the courthouse doors, if you will. There are different vendors that have been in the private ODR space that are saying, you know what, we need to be in courts, public ODR, court annexed ODR, court supported ODR is where we want to be. How do we integrate with courts? How do we work with their Zoom? How do we work with their case management to broaden the virtual services they're providing? So there's a lot going on. These are just a few of kind of the most well-known. Turbo Court, for example, is partners with courts, and I think it's 18 or 19 different states now. So there's a lot of choices and options going on. Before I turn to security and take us down kind of the other side of the hill, I want to own this is not everywhere, right? This is not happening in every court. This is not happening in every state. I own that. I think that's true. But it does remind me of the saying that we tend to overestimate technology in the short term, but underestimate it in the long term, right? So this isn't happening in every court in the next 6 months. But it is happening in a lot of courts now, and the trajectory in the past 10 years of kind of this public ODR space and these new doors into virtual courts and court systems is just explosive. And it's not a COVID thing, right? It perhaps got a little bit more attention, but it had been certainly trickling well before that. Alrighty, so who cares, right? That's going on, a lot of doors in the court. So what? So that matters, right? Courts have a lot of interesting information. People have a lot of risk when they're sharing certain things, and there's a whole host of things to worry about. So of course, courts have always been concerned about security. Lawyers did not want to leave witness outlines on the conference table. They didn't want their clients screaming about their testimony in the bathroom stall. It's easy to kind of think about security in that very physical sense. Yes, pandemic prompted, we all know, make sure you update your Zoom. You know, I'm not going to waste time on that because we have probably heard that so much in terms of how to interface on a video conference safely. And that gets back to kind of our little security checklist earlier. Do you know right now that your Zoom is up to date? Do you know that no one is listening through the walls next to you? Do you see the green lock screen at the top corner of your Zoom session to know that Washburn is using a secure Zoom account to record this, which they are. I did see that when I logged in, right? And it got me thinking kind of what do courts say about this? And if you Google any court, especially the federal ones, they have pages and pages and pages of all this instruction, which is overwhelming to me, a law professor who is interested in this stuff. And that got me thinking, if this is overwhelming to me, how much is the average ordinary user of a court service really kind of paying attention and caring about all this? So who do we worry about here, right? Kind of from the highest level, court administration. We hope that courts, as they're pursuing these partnerships or developing their own kind of online interface and different platforms for folks to interact with the court, that they're doing it securely, that they're using companies with top level security. We want people, if they're going to interact with the court system, to trust it and feel safe. And that's where we get to a little bit of our digital divide. A colleague of mine had a friend in Texas who worked at a clerk's office. And last year, the clerk clicked on a phishing email, right? A suspicious one with all crazy capital letters and colors, and ended up, infecting the entire network. And the clerk's office kind of shut down for the day. And it was a big deal. But that, it was an inconvenience then, but it can become more than that when we think of kind of nefarious purpose, hackers, user error, right? Not all of this is criminal. Sometimes it's as simple as carelessness. So from the court kind of big picture admin point of view, we hope that the systems that we'll be developing and the vendors with whom court systems are going to be working with are that top level security. Lawyers, Charlie earlier kind of mentioned the case with the lawyer behind the scene at the deposition, right? The reality is none of us know what each other are doing right now, whether we're on Zoom, whether I upload a document in the course of an online divorce mediation. I don't know where that document's going. I don't know who's going to then disseminate it. There's kind of a sanctity of that physical space. You know who's there, right? You know that they can't take the exhibit off the table and run out the courtroom door. You lose that online. I don't know what you all are doing with these slides right now. If we upload something in the chat, right? It's not necessarily just there. It's not necessarily secure. So from the lawyer's point of view, thinking about the model rules and our duty to keep things safe, the ABA had an opinion in 2021 that talked about lawyers practicing virtually and all the things we must do to kind of take reasonable measures. And we all know it's kind of that classic, what does that mean? And the ABA said, well, the more sensitive the material online, the more heightened your security measures need to be. So that's something lawyers are going to be wrestling with in terms of the type of case and the type of door, frankly, that they're using or their clients are using to interface with the court. And then the public, again, thinking about users and back to my Mr. and Mrs. Suffolk divorce example and Charlie's possibilities of mischief, right? There's a lot. And all of that kind of, when we get into deep fakes and audio kind of adjustments and all of those scary things that we hear about on the news, again, it's not happening next week, but it is happening when we think about confidentiality, medical things, privacy obligations with materials we have, and that idea of this new virtual kind of electronic permanency, I think is the best way to think about it, about everything that now the courts are kind of having come in their door. So kind of my guess, to the extent I have a thesis here, besides just throwing a lot up there of interesting, scary ideas, is this kind of creating the next divide? So, Charlie talked about kind of rural communities in Pennsylvania, and no, those courts probably aren't going to be on Zoom. And I think the underlying reason for that it didn't even need to be said, was because those communities can't necessarily access Zoom as reliably as all of us on this call, right? Hardware, broadband internet, kind of all of those things some of us take for granted. And so I wonder here, as beyond Zoom, right, not just video conferencing, but ODR services and other kind of court annexed online dispute resolution tools for access to justice topics and claims like family law and traffic and small claims and housing. If we start to kind of if the courts push people, for lack of a better term, to that type of virtual resolution, I worry about who's being pushed there and who's being left out. So the pushback is, well, this is premature, this is isolated, courts really aren't doing this. Plenty of people can still walk in the courtroom door. Yes, but also, like I said, courts are doing this and vendors are pursuing this, and there are real accessibility and fairness issues in terms of wanting the public to trust the court system, whatever that system is going to look like. I always like to think when I do presentations about technology, if I had said these remarks 2 years ago, what would they have been? And if I gave these same remarks in 5 or 10 years, what will they be? Right. And on this topic, frankly, that's fascinating. And I don't know what they're going to be, but I do worry about, populations of certain age and ethnicity and rural populations and all sorts of other studies that show that really the playing field here is not so even. Luckily, with ODR, Pew Charitable Trust, the National Center for State Courts, people are paying attention to this growth. And there's huge institutional studies now saying what's going on, how is it affecting the public, and where do we need to go from here? So I love this quote, and I think this cuts a little bit, I guess, to the extent we want a little bit of a split in our panel today against perhaps some of what my co-panelists were thinking in terms of change. But sometimes I think no change is the least likely future, to quote the famous Richard Susskind. So if that QR code, which I assure you is safe because there is a such thing as malicious phishing QR codes, if you're interested, takes you to a Google document where I have listed a few other additional resources. I am not the first to talk about these important topics. I am not the last. I am simply kind of bringing it for some food for thought today. Amy Schmitz at Ohio State Law is the leader in kind of ODR in general and court ODR initiatives, and her scholarship is just fabulous on this area. So I think we're trickling in that direction. Again, the premise of my remarks, 2 things are going up, right? More virtual doors into court systems and more security threats, concerns, and folks who maybe are up to no good. And when you put those 2 things together, it's just going to be kind of a careful parallel to watch in this next phase. So let me stop my screen share. Hopefully I kept us within time and we still have an opportunity for questions and discussion. And that's about it.
We do. I want to take the time to thank both Professor Marder, Mr. Gibbons, and Professor O'Leary for your presentations and your perspectives. I would like to open the floor for questions. So I guess the best way, since we don't have a chat box, would be to raise your little hand, and I'll try to see what hands I see on the screen. Since I don't see a hand just yet, I'm going to.
I think Jake has a hand up there.
Oh, Jake! Hi, Jake Overby. Did I say your name right?
Yes, you did. One of the few people that actually get it right.
That's because I have a fun last name and a fun name in general. Go ahead. Please let the speaker you're directing your question to know, and if it's to the panel in general, please let them know.
Okay. My question is primarily for Mr. Gibbons, but I think Professor Marder might be able to provide some insight to it as well. Really, the whole panel could, I think, provide some insight. But I am a notes editor in Washburn Law Journal, and I wrote my note on the impacts the pandemic had on collective bargaining processes, specifically looking at the NFL and their COVID-19 policy last season. And one of the issues that became really clear early on was the supreme lack of contingencies that the pandemic exposed. And one of the things I tried to focus on in my note is planning for those contingencies for the next great calamity. So with that in mind, obviously, Zoom filled the vacuum that the pandemic left, more or less, but it obviously, as we're moving out of the pandemic, isn't functioning the way we would like it to. With that in mind, as these developers for the alternative court programs and virtual court programs are creating these programs for the next future calamity that we might face, what kind of features and issues should they be focusing on so that if we have this issue again, we're better prepared moving forward, at least virtually?
Well, that's very difficult for me to answer because, as I said, here in Pennsylvania, the court system shut down during the pandemic and did not reopen until COVID was pretty much behind us. And I think that was the exact correct approach. Now, did they remain open to do the kinds of things such as administrative proceedings and status conferences, some of those things? Yeah, that stuff still went forward, but the trial system itself shut down, and I think that was the correct approach to take. And I think when there is the next pandemic, I would hope that the Supreme Court of this Commonwealth would proceed exactly as it did with COVID and shut it down until we're past it. I can't speak to the NFL because Art Rooney of the Steelers is a partner of mine in this law firm, and we represent the Steelers. So I'm going to take a December 6th or January 6th pass and decline to answer on grounds that it could incriminate me. But skipping the NFL piece and moving on to trials, I just think what we did here was correct. And I would hope it would be done that way in the future.
And I guess I would add, I don't know if you heard the speaker before this panel, Professor Neil Feigenson. He talked about sort of the next generation of Zoom and how some of the problems that we've identified with Zoom, people thinking about virtual courts are trying to take account of, such as being able to actually look at the person you're addressing and having movement so that you see like the whole person or the whole avatar. This is not an area that I really want to imagine, but I'm willing to look at what other people have written. And there are at least two researchers, David Tate in Australia and Meredith Rossner. I think she's now in Australia as well. And they've written about what these courts might look like. They've shown sort of film clips of what they might look like. So if you're really interested in seeing how people are thinking about and sort of preparing for the events you're talking about, there are people out there trying to imagine what this looks like. I'm going in the opposite direction. I want to just pull back and have us return to the courtroom. So I'm not the best person to ask about this.
Okay, there are a lot of eager hands. So I'm going to say that I saw Emma Stat's hands next, and then Gabe Tenenbaum, you'll be on deck, followed by Elisabeth, followed by Taylor. So Emma, if you're there, you can go ahead and ask your question.
Yeah, I was just going to briefly follow up to Mr. Gibbons, your response to Jake's question. So as you pointed out, the Pennsylvania system shut down as far as trials go. I was just wondering your perspective on if that creates any due process issues, just with the fact that obviously, there was the alternative for Zoom as other states were doing, but you find that Pennsylvania went the correct route here. Do you feel that made any due process issues, or those were justified, or what is your view on that?
Well, certainly in the federal courts, since you have the Federal Speedy Trial Act, and I do not practice criminal law, I don't think there were any issues from the federal standpoint, or if there were, I certainly didn't hear about them. I don't want to suggest that during the pandemic that cases came to a halt. I will tell you this, that 50 years ago when I started here in Pittsburgh, we would all wait for that magic date of June 15, when all the judges went on vacation and the court system shut down until after Labor Day. And for the first time in your life as a young associate, you could actually breathe in and breathe out, go home and see the kids and play with the dog. That disappeared probably by the end of the 70s into the early 80s. And now the court system, or thereafter, the court system ran year round. The federal system here always ran year round. During the pandemic, cases continued to proceed in some aspects of discovery, such as document production, interrogatories for those who continue to use what I think is a rather useless vehicle. There were conferences with the judges. So we didn't come to a halt. It's not as if we all went on vacation or went home and quarantined. As far as due process issues on the civil side, in those instances where there was, for example, testimony that needed to be preserved, perhaps because a witness was suffering from a virulent form of cancer, a terminal form, that stuff continued. So we didn't come to a complete halt. We simply did not take that last step of impaneling a jury and trying the case. And beyond that, in terms of where could there have been due process issues, I suppose, but none to my knowledge.
Thank you.
Okay. We had Gabe, you were up next, and then I did see your hand come up, Sam. So I think it's Gabe, then Taylor, or was it Elisabeth? Maybe Gabe, Elisabeth, Taylor, Sam. Okay.
Thanks, LT, and thanks all. My name is Gabe Tenenbaum. I teach at Suffolk Law, and I have a question for all of the panelists, with full disclosure that Dyane is a respected colleague, collaborator, and peer, but she doesn't get a softball pass from me. But I'm curious, Professor Marder and Attorney Gibbons, it sounds like generally you're resistant to the use of Zoom or the expansion of Zoom. Dyane, it sounds like you're generally have the door open to it in the right circumstances. I'm always curious about sort of strong arguments in the other direction. So I wonder if you'd be willing to entertain what it would take for you to change your perspective. In other words, what's the best possible argument for the opposite position of the one you've taken today? And hopefully I'm not putting words in your mouth by saying, you know, in an unnuanced way that you're for or against this, but that's my question.
I'll take that one first. Data that comes out over the next year showing that this public ODR graph starts to go like this, right? Because up until now, over the past 5 years, it's going like this. So until it starts to go like this, I'm paying attention. And the other pushback is ODR is for small value stuff that no one will care about. So security concerns aren't that big a deal.
So here's an argument that I'm willing to think about how I think about this issue. Right now, I'm up in Toronto, Canada, doing research by watching courtroom jury selection because they recently eliminated their peremptory challenges in criminal cases. So I wanted to see how that was working. And I'm a big believer in being present in the courtroom, as you can tell from my talk. And I'm, to add maybe insult to injury, I'm against cameras in the courtroom because I really believe in the presence of the courtroom and of the jurors and the out of the ordinary experience. But what I'm finding as a researcher is the courts, I'm in Toronto, the courts are making it extremely difficult for the public to find the jury trial going on. First of all, there are very few jury trials, even in criminal cases. And I'm a very assertive researcher. I am going out of my way. I am sitting with the jurors in the jury room. I am befriending the jury administrator. I am walking around chasing after jurors. I am doing everything possible to find out where that jury trial is taking place. And I am having a really tough time. So I might at some point rethink my position and say, all right, maybe we need cameras or the next version of Zoom or something because it'll reach a lot of people. Because what does it mean to have a public proceeding if I'm the only member of the public attending? So there is something wrong with that. And I didn't expect to encounter that, but it is making me rethink, you know, what does it mean to be public? And maybe I have to change my views.
I guess my answer, Gabe, would be to cite to, and I can't, I'm sure Professor O'Leary and Professor Marder might be able to do it, but all those studies that have looked at Zoom technology and the other advanced technologies as creating a very lonely American society where we don't have to get together anymore because we can do this stuff. And I can see Elisabeth thousands of miles away and we never have to meet, but we can converse or bully each other as sometimes happens. Is that a world you really want? Was there something wrong with the English all those years ago to decide that cases really should be decided by going out amongst the gentlefolk or those who had windows in their houses to have them come in and sit as jury persons? I don't want to think on the other side. I don't think there's any need to think on the other side. I grant that there are some very, very positive elements about this technology. But I would also hearken back to the fact that when the automobile was invented, it changed our society and in many ways for the better by giving us a mobility that we never had before. And boy, did we put it to good use. Except all these years later, we find out we've been poisoning ourselves with those very automobiles that spew gasoline or diesel. And now we have to think in another way to maintain what is a good, which is that mobility that the automobile or the vehicles gave us. So I am disinclined to think in the context of what I have done for a living in the last 50 years to think, is there anything positive beyond the administrative stuff, the stuff that you really don't need to come to the courthouse, as that federal judge told me, that she can get so much more done and can get those issues decided by Zoom or by telephone or by other technological means. And I'm willing to stop right there. And if there's some other way that comes along, I'll at least think about it, but not in terms of trying a case. And we've all seen how this technology can be so badly abused that some kid on Cape Cod is being bullied by students 100 miles away in the mother Bay State, such to the she can't even go to school anymore. And those are not isolated cases. We all know that. So I'm just not willing. I'm not willing to go there, Gabe.
Thank you all.
Elisabeth?
Yeah, so my question is specifically for Professor O'Leary. You ended your presentation talking about how we're going to see more virtual doors and more people up to no good. And so my question is, what does that mean in the context of a time where more people are putting personal information online? You know, you can go online and see somebody's TikTok, Instagram, Facebook, LinkedIn, and have all this information. And so part of my question is, do people care about their security or privacy? Yeah, that's my question.
Yeah, thank you for that. That's a really good question. And that's a lens I haven't thought of. So I think I'm kind of assuming that users of any type of kind of court annexed process to resolve a dispute would in fact care about that. But your lens is interesting, perhaps kind of society-wise, no. But I think there's a difference between us being okay with our decision to do that, right? Kind of confidentiality and privacy are like individual rights that then the law gives certain protection to. So we can say, you know what, I'm okay with giving you, Elisabeth, my medical history, but I'm actually not okay giving it to the Boston Globe, right? But this idea is once it's out there electronically with that permanency, it's not my decision anymore. So I guess that's how I see it a little bit differently, that people might be lax, for lack of a better term, in their personal use because that's up to them. But maybe not as much when it's not up to them and things they're sharing are being used inappropriately. But I hadn't kind of looked at it from that more, I guess, kind of socio-economic lens. That's probably not the right word for it, but that's an interesting point.
Thanks, Professor.
Taylor?
Hi, I just first want to say, Mr. Gibbons, it's nice to see you again. You came and spoke to our evidence class last fall and we all had your book, so it's good to see you. But I also have a question for Professor O'Leary as well, and for anyone else who cares to chime in. So I really think that the increasing use of technology, either through alternative dispute resolution or the court system, seems like an inevitable reality. Not necessarily that there are good that comes along with it, but some of the concerns which you all touched on that I see is really like complying with the rules of professional conduct. That's what comes to mind for me specifically. Like your list of security checklists that you showed, Professor O'Leary, I was like, wow, that's huge. So I guess, and also you can't really control like what clients do. And so I guess, what sort of advice do you have for us going into the field to sort of avoid some of these negative consequences that result from the lack of security?
Yeah, thank you for being aware and thinking about those issues. So the law, meaning the rules of professional conduct in this sense, like so much of law and technology, is steps behind. Right? Like that's just the reality. And so we almost kind of all play catch up. Like, what are our obligations again to this thing we've been doing for 4 years? And just now the ABA says, well, here, lawyers, here's what you should be doing. So the book I just wrote has an entire chapter on kind of this for lawyers, down to like, if you're going to use Google Drive, like what do you have to do before you do that? And so the ABA just came out with an opinion actually yesterday talking about whether if you copy a client on a text or an email chain and someone else replies all, do you impliedly consent to them contacting your client? Right? And the ABA said, yeah, you kind of do, or else stop copying your client on everything. So, but again, people have been replying all with their clients for years, and the ABA is now just saying, okay, yep, okay, that's fine. So I think, the best thing to do is, this sounds like a easy task perhaps, is to stay abreast of what's going on. So the model rules 1.1 competency now has a comment adopted in 40 states, and I don't know if it's in Kansas, but it probably is, that says lawyers have a duty to stay abreast of the benefits and advantages of relevant technology. And that means that, right? That it's not okay to just kind of put your head in the sand with it. So I think kind of down, thinking about different categories of your practice, your hardware, your work setup, your desk, have a clean desk policy, very simple things like that. And by clean desk, right, I mean kind of a clean screen policy. So I think that's a thing that you and a client can focus on. And then there's the bucket of cloud-based use, right? Where are you storing things? Are you texting a client instead of using a secure portal for privileged things? So I think if you think of your practice in those buckets, like my hardware, my remote work, and my cloud-based work, and then you think about your client interaction in those buckets, I guess all of that would be the best place to start. But good for you for even thinking about that. And yes, it's a very hard task, is my summary.
Okay, I'm gonna give Sam the last question.
Thank you for the honor of the last question. I appreciate it. So my question is for Professor Marder. You spoke about voir dire, so I have a question for you. So in Kansas, we're one huge federal district, and all the courthouses, though, are located all on the eastern side of the state. And so here in Topeka, someone gets called for federal jury duty. A lot of times about a fourth, maybe a third of the jurors will have to drive 2 to 3.5 hours just to get to the courthouse that day for jury duty. So do you think there could be any role for Zoom in the voir dire process, alone, to maybe alleviate some of that burden on jurors, and then if they get chosen, then drive in and stay, versus, because I have witnessed jurors who drive all the way here, get struck almost immediately, drive all the way back, and compare it to the jurors who live in Topeka and have to drive 10 minutes. So I was just curious about your thoughts on that.
Well, I sort of wonder, I certainly recognize that problem, and I don't want jurors' time or prospective jurors' time to be wasted either. And I don't want courts to waste their time. I'm not willing to change voir dire because I think it's really important what goes on in the courtroom. But maybe one way of addressing the concern that you raise is through, usually along with the summons, either with the summons or separately, you might get a card that allows you to fill out qualifications. And if there's a question about, how long would you have to drive, and how much of a hardship would that be? Maybe some of that could be handled just through the qualification or excuse problem, so that, I don't want to eliminate those people either. But for people who have an excuse, let's say, in addition to they live really far away, they have problems understanding English, they have a financial hardship, all of those kinds of reasons, so that when they would go to the courthouse, they would then be excused rather than making them come to the courthouse at that point. You could do it just through the mail. That wouldn't address everybody's issue, and I don't want to rule out people who, even if they live far away, are willing to do that anyway. But that might be one way of doing it. Again, back to my Canada research, I watched one jury selection where they brought in 100 prospective jurors, and many of them had excuses. And so a lot of those excuses could have been addressed just through summons and qualification. And you didn't need to bring in people in that manner because the kind of excuse they had was, I don't understand English very well, or I have extreme hardship. And again, so that might answer your concern in places where there's a huge amount of driving that's required.
Thank you so much for speaking to us and serving on this panel today. I think it's been a treat for everyone that got to listen and for myself to have the ability to moderate and participate. And with that, I'm going to turn it back over to the organizers of this, Elisabeth and Marisa.
Yeah, I just want to also, reiterate how thankful we are that you guys could all join us, both those in the virtual audience and our speakers. I know we had anticipated for in-person, and there were so many moving parts to it. And I don't know who was here for the morning panel, but someone actually just, tested positive and wouldn't have been able to make it anyway. So, everything happens for a reason, I suppose, in the Zoom era. But I do want to thank everybody just for being so amenable to the changes that we made last minute. It's much appreciated. And I had a wonderful time listening to you all today.
And with that, we will conclude the symposium. So thank you again all for your time, for the presenters who spent time researching, presenting, preparing your presentations. We appreciate it. For the moderators, LT and Professor Ewert, thank you again for your preparation, and to all of you for coming. We really appreciate it. And I hope that you have a good afternoon, either on Zoom or in person, your choice. There's pros and cons to both. I think that's what I'm taking away from the symposium. But thank you, everybody. And with that, we will conclude.
Elisabeth, you might mention which version of the Law Journal articles will be coming out in.
Yes, so several of the professors' articles will be coming in the third issue of the 62nd version, or the 62nd volume of the Washburn Law Journal.